Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss the case of SHYAM GIDWANI versus Income Tax Officer. This case has been decided by Jaipur ITAT and the matter has been reported in 98 ITR Tribunal at page number 665. The date of the judgment is 21st October 2021. In this case, a very important issue has been settled by the tribunal, although there is no dispute about that fact, but there is a litigation on that point very much. The point is that in section 148, as we know that there is a lot of litigation as far as the issuing of the notice with the permission of the higher authorities, because the law has changed many times, whether the permission of the joint commissioner is required, whether the permission from the principal commissioner is required. So, although there is a clarity in the law that if the notice is issued after 1st June 2015, the law has been changed from 1st June 2015 that if the notice is issued beyond 4 years, the principal commissioner is required, and before that the law was that if the notice is to be issued beyond 4 years, the permission of joint commissioner was required. In this case, the notice was issued on 18th March 2015. So, and the permission of the joint commissioner was obtained. But the assessee was saying that no, the permission of the principal commissioner is required. So, the Jaipur ITAT said that as far as the seeking of permission of the higher authorities is concerned, section 151 is applicable, and what is to be seen is that on the date of the notice, what is the law? If on the date of the notice the permission of joint commissioner was required and it was taken, then it is okay. The problem arises in a case where the notice is issued after 1st June 2015, but the case relates to the previous years. So, the doubt may arise that if the notice is related to the previous years, so whether the permission of joint commissioner will be required or principal commissioner will be required. So, in this particular case, it is well settled that you have to see on the date of the notice what is the law. So, in all those cases where the notice is issued after 1st June 2015 and when the notice is beyond 4 years, it doesn't matter that the notice relates to the period which is before 1st June 2015, the permission of the principal commissioner will be required. The second issue was that in this particular case, the assessee didn't ask for the reasons from the department. The department didn't give the reasons, and so the assessee was not able to raise the objections. After completing the assessment, the assessee was raising the point that the order was passed without meeting my objections, without considering my objections. So on this point, the ITAT said that it was the duty of the assessee to seek reasons from the department. If he has not seek the reasons, then he cannot plead. Then that my objections has not been disposed of. So friends, this case is very important as far as throwing light on the subject that whether the department will suo motu give the reasons, because if you expect from the department or the administrative authorities that they will come with clean hands, they will provide you all the informations, then it is very doubtful. It is the duty of the assessee to ask again and again the reasons from them, then raise the objections, and if the objections are not disposed of properly, then again ask them to consider my objections. So if you have not asked for the reasons, then you are at peril. And the second issue, which was well settled, that it is to be seen on the date of the issue of the notice whether the permission of the joint commissioner or principal commissioner is required. So if the notice is issued after 1st June 2015, then the new law will be applicable. At the end of this video, once again I am repeating the name of the case. The name of the case is SHYAM GIDWANI versus Income Tax Officer. and this case is particularly on the time limits and regarding the proper sanction of the higher authorities in issuing the notice under section 148. This case has been reported in 98 ITAT Tribunal at page number 665. Thank you, friends.